name is Senator Steve O'Ban, and I represent the 28th Legislative District, which is the Lakewood-Steilacoom Furcrest area of our state. And we're here to respond to the governor's blanket moratorium on death penalties in the case. In my judgment, that moratorium is as much a misuse of power as it is a blow to justice for the victims and their families. I'd like to address several points raised by the governor's comments, raised by the governor's actions yesterday. The first is that the governor increased the chance of another death row murderer like Brian Sheriff, who strangled a corrections officer, Jamie Bendel, in the chapel of the Monroe prison. Mr. Sheriff was there serving a life sentence without parole. He murdered Jamie because he was trying to escape. One correctional officer said that the governor's action is an open season on correctional workers, particularly those where they are watching over prisoners who are serving life sentences and have nothing to lose if they kill another corrections officer. And it disrespects, this corrections officer said, it disrespects the conditions under which these men and women serve at risk of their lives. Ironically, Sheriff himself said that he thought the death penalty was appropriate for him, that was the just thing to do. The governor has denied also the prosecutors a very valuable tool. In the Ridgway matter, prosecutors were able to assemble evidence to bring 7 murder charges against Ridgway. But because they had the capital punishment as a hammer over Mr. Ridgway's head, they got him to confess to a number of other murders, and so there were 48 charges that were brought against Mr. Ridgway, and those families had truth finally and had some form of justice that they would never have otherwise had if prosecutors didn't have the death penalty at their disposal. The governor claims that his action yesterday will save the state money because of all the money spent defending against the appeals of these death row inmates. But in fact, the appeals aren't going to stop. A good defense lawyer is going to continue to preserve his or her client's rights and prosecute those appeals and file new appeals because the governor's action is only as long as he's in office. If the governor shouldn't seek re-election or be re-elected, that moratorium could very well be taken away by the next governor. So those appeals are not going to stop, and prosecutors throughout the state who've responded to this action have said we are going to continue to file capital murder cases where it's appropriate. And in my judgment, the governor abused his power of clemency and has co-opted the role of the legislature in this case. His job, in terms of his clemency responsibility, is to judge cases on a case-by-case basis. Where there has been an abridgment of due process rights, there has been a disproportionate application, perhaps, of capital punishment, that's when he should act in that particular situation. The Constitution doesn't allow him to make a blanket moratorium on death penalty cases, and in fact, that constitutional right is limited by, as provided by law, and the law in this case is that he needs to submit these capital murder cases to the clemency board, give them a chance to review the case, to hear from victims, to look at mitigating factors, and then have the clemency board make a recommendation to the governor, all of which the governor sidestepped yesterday. And then I want to just talk about 3 cases from Pierce County, from my area. And then I want certainly give these other 2 gentlemen a chance to give their comments. And that is, the governor talked about how there, in some cases, isn't sufficient evidence. There's the question about guilt of those that are on death row. Cecil Davis. Davis raped and then suffocated a 65-year-old woman, Yoshiko Couch, using a poisonous substance. He told witnesses beforehand that he needed to rob someone and he wanted to kill someone. The victim's blood was found on his shoes, as was the poisonous substance. He was found wearing the victim's gold wedding ring. Alan Gregory plunged a knife into the back of Janine Harshfield. She was 43 years old. He stabbed her in her kitchen, and then he dragged her from the kitchen into the bedroom and he raped her. He stabbed her again and killed her. His semen was found on her and on the bedspread. And I have a quote I wanted to read from Ms. Gregory's, from Ms. Harshfield's mother, Lee Peden. I think the governor's wrong. This is about the will of the people. The people of Washington voted for the death penalty. If the death penalty is going to be rescinded, then the people need to have a say in that. I know there are people who don't believe in the death penalty. Reasonable minds will differ on that. When you sit in a courtroom and have to listen to what was done to your daughter and how violently her life was ended, do that, and then tell me you don't believe it's justified. I voted for the death penalty, never believing that it would personally impact my life. I watched as 2 juries unanimously put Alan Gregory on death row. That's how the system works. The governor needs to honor the will of the people. I agree with Ms. Peden, and the system in place in our state is it's the legislature that decides whether this is an appropriate penalty across the board. It's the governor's job to decide if in a given case that penalty has been applied inappropriately. The governor's gone around the prerogatives of the legislature. By the way, there have been 5 bills recently proposed in the legislature that went nowhere. And that's because the legislature, at least in those cases, and as recently as 2012, do believe the death penalty serves an important purpose. That's reflected by the will of the people. And I'm just disappointed that the governor has essentially usurped his role, gone around the legislature, and substituted his judgment for that of the people. Representative Rudd, Jay Rodney.
Thanks, Senator Ban. I'm Jay Rodney. I'm the ranking Republican on the House Judiciary Committee. I represent the 5th District, which is East King County. And I just want to reiterate the comments of Senator Ban that, I question the timing of this announcement by the governor. We could have introduced or had hearings on bills prior to the policy cutoff date. And I think that there would have been interest in having this discussion this legislative session. The question, that in terms of the timing, now the legislature can't act on anything until the following year. Again, I just question the timing of this announcement by the governor and wonder what the motives are. I think it's highly insensitive to victims' families, particularly the family of Jamie Bindle, the family of the 4 Lakewood police officers who were assassinated. I think it's highly offensive that those family members are not going to be given a voice in this issue. And I do believe that it is a legislative matter. As I indicated yesterday in some comments, if there is legislative support for this policy change in the abolition of the death penalty, then it ought to come from the legislature. It ought to come in response to full public hearing and transparency, where victims' families are afforded the right to comment and to have their voices heard, where advocates are able to have their voices heard, and then we need to have a vote in a full and transparent process. This is also, I think, highly insensitive to those on death row right now, because it certainly is not it's a reprieve, which can be rescinded by a future governor. And so I think it's cruel to those capital defendants who now have another measure of uncertainty that has been inflicted in their cases. So, as I mentioned previously, a few years ago when my colleagues on the other side of the aisle had supermajorities in both the House and the Senate, as well as the governor's mansion, there were bills introduced that went nowhere. And so I think that this is a policy that ought to come from the legislature, not from the governor. And I would welcome that discussion. I would welcome that debate. And I think we owe it to the victims' families as well as the citizens of the state of Washington.
Senator Pearson.
Thank you. I'm Kirk Pearson. I'm a state senator for the 39th District, which includes the Monroe Correctional Complex. And as you know, you heard mention of the Jamie Bendel tragedy that occurred with Brian Sheriff murdering her. In living in that community, I will tell you, not a day goes by when I go back home in my district, I come across correctional officers still upset, still concerned about staff safety within those walls. Still tell me that we still don't feel safe enough. And here, with all that information, you know, the governor's office knows these things. But still, he came out to the shock of a lot of us, has gone around the legislative process and declared during his tenure he's not going to allow an execution in our state. We must realize part of having capital punishment in our state is to bring closure. Closure for families of the victims. And with what he did, he said there's not going to be any closure. And I think it's really totally insensitive to those families. I really hurt for them. I've been on the Public Safety Committee and Law and Justice Committee around 12 years of my tenure here in the legislature. I've talked to victims of families of violent crime, heard their stories, the tears, and what they have gone through. What the governor has done, he's put politics over victims, and that really concerns me. The timing, and especially not conferring with the legislature. So I wanted to come. I'm extremely shocked and dismayed that he'd make such a decision, especially without even talking with any of us. But especially the victims, they needed that closure. They want that closure. But the governor says there's not going to be that closure. Thank you.
Two of you have mentioned either questioned his motives or putting politics over the victims. Other than I'm assuming this is a sincere wrestling with his own conscience over the death penalty, what sort of sinister motives or what sort of politics would be involved with this?
I don't think I was one who.
Yeah,
Well, I don't. Yeah,
Okay.
I don't want to assign motives, but I do think that just last year there was legislation introduced, and I've worked with the governor's staff on a variety of matters this session, and not once has any member of the governor's staff mentioned anything about wanting to revive a discussion about the continued efficacy of the death penalty in Washington State. And so why now, just after the policy cutoff, and we're halfway through the session, does this pronouncement come? Again, I'm.
He wasn't introducing a bill. He was doing a moratorium, which is you'll probably have Reuben Carlisle introduce this bill again next year.
Well, I think the bill is continued to. I think it could be revived. This session, and moratorium doesn't, as Senator Mann said, doesn't change the process. Attorneys will, again, on both from the prosecution and the defense side, have to fully prosecute these cases. Moratorium does not change the process. So if the governor was sincere about changing the process, there should have been some legislation introduced, and we should have had a transparent, open discussion about, again, the continued efficacy of the death penalty in Washington State that would give both victims' families the right to have their voices heard, as well as all stakeholders in this matter, prosecutors, defense counsel, and victims advocates.
Senator Roby, I'm a little confused because on the one hand you said the governor denied prosecutors a valuable tool, and on the other hand you're saying prosecutors are going to seek the death penalty anyway. So how can he have done both? How can he have denied them that tool since they're going to keep seeking it?
Well,
you say
sure, I know.
His predecessor or his successor could change this.
Well, by instituting this moratorium, if you're now, let's say, negotiating with a aggravated first-degree murder defendant, I can hear the defense lawyer saying, well, yeah, you may think you can get the death penalty in this case against my client, but the governor just put this moratorium into effect. We don't know when or if it will ever be lifted. And so that certainly could have a impact, I'm sure we could all imagine, on the negotiations that would take place. So my point simply is, it certainly undercuts a prosecutor who, as in the Ridgway case, would want to try to use that to get the defendant to admit to the crime and to admit to other crimes that he may be having a hard time convicting on. And to your question, your point about prosecutors, they will continue to file charges. They're required to. There's a state law that says we have a capital murder penalty here, and where appropriate, in the right circumstances, they take a notice of the Constitution, and they're going to continue to follow the law and file in the appropriate situation.
Would any of you support full state funding of death penalty prosecutions, so it wouldn't matter what county the crime was committed in?
I want to speak to, here's some of the governor talks about he wants a discussion. I think a moratorium shuts off discussion, and he said he'd been mulling this over for a number of months, but never brought, to my knowledge, in the legislature. I sit I'm chair of Human Service and Corrections and vice chair of Law and Justice. I was never brought in any of those discussions, so I don't think they've taken place. One of the discussion points we could have is how do we narrow these appeals so they can be done in a bundle, they can be done more efficiently and effectively, rather than done piecemeal spread out over a long period of time. Texas, for example, has as I understand, has a separate criminal appeals process where these kinds of appeals then can be heard in an expedited fashion. They don't have to wait for all the other appeals that are making their way through the regular appellate process. So these are some of the things that we could consider as a legislature if the governor wants to look at what he says is a problem of cost and of delay. I think there are things we can do. There are things other states have done. So it's a great discussion, but it seems to me we should have started that discussion before the legislative session began and before the bill cutoff period came.
You expressed concerns about safety for correctional officers, but Jamie Bendel was killed when there was not a moratorium on the death penalty. So how are correctional officers any less safe now that there's a moratorium than there was before? And if there's a concern about safety, what can you do as legislators to ensure that something is done within Department of Corrections separate from the moratorium to ensure their safety?
Regarding correctional officers' safety, issues have been brought to me from correctional officers. I have taken it to Secretary Warner and their concerns. We did originally, when Governor Gregoire was in office, we had that correctional officer safety bill after the Bendel murder, and where we did allow use of pepper spray and certain procedures, movements within and out the prison, how people will be guarded and staffed, but still there still is a concern, and I hear from my correctional officers that they still have safety concerns within those walls.
But why is that impacted by whether there's a moratorium on executions or not? What's the nexus there?
Because I think what happened in Monroe, it had such a deep wounding effect to every correctional officer. They feel that, yeah, granted this happens across the country, but they want to know that we're doing the best job possible to make them feel safe. And I know this is just a number of people that we're talking about, but still, what happened to Jamie Bendel has affected every correctional officer in the state, and they want to know that the governor stands behind them.
But it sounds like it's more of a closure issue for correctional officers
Yes,
than a
it is.
safety issue.
Well,
Because you were stating safety, so I'm just curious.
Yes,
if safety
I
matters.
believe there are some safety issues that we still have to look at. But yeah, it's a closure issue also.
Let me talk about the nexus to your question. So sheriff was in there, life sentence without possibility of parole. So with a moratorium on a death penalty, let's say that this had happened, this moratorium was in place when he did this, he could effectively say, I can take this officer's life and I'll never have to pay the ultimate price. I'll never have the death penalty imposed upon me. And that's, I think, the concern of correctional workers is now the message is sent certainly to those who are serving life sentences without possibility of parole. Without the possibility of the death penalty now, you can take the life of other correctional officers and there'll be no penalty.
But Sheriff didn't, even though he was facing the death penalty. So I'm having trouble with the logic there that it makes it more dangerous. Because Sheriff knew that he faced the death penalty and he didn't.
We don't know what went through his thought process at the time, if he was thinking about that penalty, but certainly other inmates who are perhaps slightly more deliberative will now think to themselves, well, if a deterrent to me was I might face the death penalty, that's been removed by the governor.
We're not the first state to have a moratorium on the death penalty or to get rid of the death penalty even altogether. Is there any evidence that more corrections workers are assaulted in states that don't have the death penalty, or is there anything in other states that's happened that shows what happens when you get rid of the death penalty? I'm just trying to work through the safety of corrections officers.
I haven't looked at that particular data. That's a good point, Jordan. Certainly look at that particular issue. But we are hearing from those who are on the line. We're hearing from correctional officers who are interacting with these inmates who are in there for life. They're afraid. I don't think that's an irrational response on their part, and I'd frankly defer to their judgment about what their workplace safety feels like over those of us in this room.
The governor made the argument about not only just the cost of the appeals process, but also the cost of the trials themselves. And there are counties in this state that don't even want to enter into a death penalty trial because they know they can't afford it. Given the committees that you all have served on, is it worth looking at least at whether or not the death penalty is applied equally in the state if there are particular counties that are reluctant to even charge it just because of the fact that they can't afford a trial like that? Should a second look be, does it deserve a second look?
Well, I certainly think that, this is a very serious policy issue, and no one takes that lightly. We do need to look at how these death penalty cases are prosecuted. There was a question about looking at how these cases are funded, and when maybe there needs to be a more significant state role in the funding of these cases to take the burden off some of the smaller counties in particular. And I would be very supportive of having that discussion as part of a larger context or a larger, broader context discussion about the continued application of the death penalty in Washington State. One thing that as an attorney, I do share concerns about the length of the appeals process, and I think that we can model what other states have done here to make those appeal processes more efficient and streamlined, and so we can do joint appeals or consider all of the appeals in one matter as opposed to, as Senator Ban said, stringing these out over decades, which is absolutely outrageous to victims' family members.
How do you bundle, say you have 5 appeals from 5 different inmates, how do you bundle them all up into one?
I don't think you bundle the.
Yeah.
No, I don't think you bundle the different inmates. I think there's
Right.
You can bring separate appeals. You can run out some issues and lose, and then you can bring another set of appeals after you've lost the first round. So I'm talking about bundling the state appeals, bundling the federal
For one
appeals.
defendant.
From one defendant, from one inmate.
We have time for one more question.
Maybe for Representative Rodney, why not take these kinds of decisions out of the hands of county prosecutors and have it be the AG? I mean, apart from the issue that maybe this AG doesn't like the death penalty, but why leave this kind of decision in the hands of a county if expense and unevenness of application is the issue? If you had death penalty teams handling all of these cases, wouldn't you have consistency?
Well, I think the AG's office is civil in nature. I don't think it's vested with prosecutorial authority and these kinds of cases under law. So there would have to be some amendments or perhaps even some constitutional issues. County prosecutors are vested with that prosecutorial authority to make these determinations, and that's the way our system has been established since the founding. And Yeah.
Would you be willing to have state appropriations to, say like Garfield County, if they want to pursue the death penalty case, would the state pick up, would you be willing to have the state pick up the bill for a death penalty case in Garfield County?
Well, we've done a lot of work on indigent criminal defense over the last several years, and I think a lot of the appeals in these cases qualify for funding as indigent defense.
But how about for the prosecutors? I mean, that's, you know.
Because otherwise, how do you address what the governor's been talking about here?
Right.
It's unequal because the counties all decide whether they can afford a death penalty prosecution. Some counties can't afford a death penalty prosecution. How do you apply that equally so all counties can afford a death penalty prosecution?
I think it's a great point. I think that might be a good use of our criminal justice money to address that issue, not just from the standpoint of proportionality,
Absolutely.
but because what we're saying here is there are some capital murder, aggravated first-degree situations that are not being prosecuted to the full extent of the law, and that should be done for the sake of the victims.
Absolutely.
I'm seeing the cutoff, but I'll be happy to
Thank you very
talk to
much.
you afterwards.
Yeah,
too.
absolutely.
Yeah.
Good job.
Yeah, you too.